Good morning, sir. Are the picture and sound working as they should?
Yes.
Sir, just a reminder that we have a fire alarm at 10 o'clock. If you're content, then we'll just stay silent for that alarm.
Of course, yes.
Thank you, sir. May we please continue with Mr. Bowyer's evidence?
Yes.
Good morning, Mr. Bowyer. When we adjourned yesterday, I was coming to the Cartwright-King review.
Excellent. I haven't got my statement in front of me.
Let's see if we can get that sorted.
That's perfect. Thank you very much.
Could we have on screen, please, paragraph 68 of Mr. Bowyer's statement? That's page 16. You describe the review process here in this way. You say, in broad terms, the process operated by the relevant files being subjected to a first sift. This was carried out by various solicitors at Cartwright-King, including Martin Smith and Andrew Bolse, and those cases that passed the first sift criteria were subjected to a second sift, which was conducted by counsel. Initially, the only counsel involved were Simon Clark and myself, but later counsel from the independent bar were instructed. The operation was conducted from the Cartwright-King Derby offices to give easy access to the files. If disclosure was required, we were advising Post Office Limited to disclose the second site interim report and the Helen Rose report. Just picking up on the last sentence there, that where disclosure was required, you were advising the Post Office to disclose both second site's interim report and the Helen Rose report. You may have seen from the papers that there are a number of cases on which you advised where your advice covered the interim second site report and advised that should be disclosed, but did not mention the Helen Rose report or advise its disclosure. So just taking an example, the case of Alison Henderson, that's the case you address at paragraph 82 of your statement. And the advice, if we can have it on screen, please, is POL 002 94503. You can see that's the case of Alison Henderson. And going, please, to page 3. Under discussion. If we can just give Mr. Bowyer a moment just to look as we scroll down that discussion section and then over the page to the conclusion. Can you see that the second site interim report is addressed and the advice is to disclose it, but there's no reference here to the Helen Rose report? Can you help with why in some cases only the second site interim report was being disclosed and not the Helen Rose report?
I'm afraid I can't recall on case-by-case basis.
Would there be any type of case where one but not the other would be disclosable?
I think there were. I think in some of Simon Clark's advices, he actually specifically disclosed one and not the other.
Could we have on screen, please, POL 001 98128? This is your advice in the case of Kathleen Crane, and you address this at paragraph 79 of your statement, if you want to see that.
Yes.
This was a Horizon Legacy case. And going to page 3, please. Paragraph 9. You say this is a pre-Horizon Online case. The second site interim report deals largely with Horizon Online. We have nothing to disclose that directly relates to the pre-Horizon Online cases. If this was a case where the allegation was one of theft or the defendant was sentenced on the basis that she had appropriated the money, the position might well have been different. To what extent if at all, did you consider that legacy Horizon cases might attract disclosure of the second site report?
Well, I think we did disclose some of the legacy cases.
Well, we can come to that. I think you've quite recently seen a copy of your advice in the case of Peter Huxham. Is that right? Do you recall?
Yes, I would do.
And if we can have that on screen, please. It's POL 0029 4518. We can see from the title here that this was also a pre-Horizon Online case. Your advice is the 4th of September 2014. And going to the discussion on page 3, paragraph 10, please. You say, this is an unexplained loss case where the defendant states that he was covering up losses that had occurred for reasons out with his knowledge. There is no danger of the defendant's conviction being found to be unsafe, as he has admitted his guilt from the very first, but he has been adamant that he did not take the money to the point of fighting and losing a Newton hearing. His explanations as to the possible loss relate to possible thefts, either by a member of staff or seemingly at the Newton hearing. His wife may well have been modified into an attack on the Horizon system had he but had the material to mount it. And then over the page, please, at 11. I doubt that an appeal against sentence will be mounted after any disclosure that we might make in this case, as the sentence has been long served. The reality is that the second site interim review deals in the main with Horizon Online, the system that superseded Mr. Huxham's system, but it did deal with the pre-Horizon Online issues, and in my view, had we had the material contained in the second site interim report at the time of the Newton hearing, we would have served it on the defence. And then the conclusion, those instructed by Mr. Huxham should be written to in order to make disclosure of the material contained in the second site interim report. So in this case, you advised the interim second site report was disclosable. Yeah. Can you help with why there was a different approach in this case to the pre-Horizon Online case, and whether there was any particular principle that was being applied at the time?
I can't help as my thought processes at the time. It's 10 years ago.
But was there a common position among those at Cartwright King, initially you and Simon Clark, reviewing cases on whether the second site report and the Helen Rose report should be disclosed in Horizon legacy cases?
I don't think there was a position. We were disclosing it in some legacy cases.
Do you think there should have been a principled approach to that?
Well, looking back, I think that we should have had a common view. You have to remember that the review process was looked at twice by Brian Altman and found to be robust, both in his interim review and his other review. And he looked at some 31 of these these advices. So at the time, we thought we were doing it right. I can see that an awful lot of these documents, with what happened subsequently, because at this particular time, this was after the second site review came in and said that the system was robust. That they found no evidence of systemic failure in it. It was only when the civil case came up in 2019, when Mr. Justice Fraser found considerably more than we were aware of at the time, that the totality of what Horizon was doing was actually made available to us. So at this particular time, we thought that what we were doing was right, and we were confirmed in that because our advices were being reviewed.
Thank you. That document can come down now. Thinking about another pre-Horizon Online case, we looked at some correspondence yesterday about the draft Gareth Jenkins statement, yes, and particularly the amendment that you made deleting the case-specific references that were in that statement, which included his involvement in the Seaman Misra case. Do you remember that?
I remember that, yes.
It was your view at the time that Mr Jenkins' evidence could not be relied upon once the interim second site report came out and
Yes.
Following that. Did you give any consideration to whether Seema Misra should be told in clear terms that the expert witness in her trial was, in your view, discredited?
Well, I didn't review Seema Misra's case, but I think my view would have been it should have been disclosed.
When you were reviewing the cases that you were, did you notice any patterns of sub-postmasters raising unexplained losses and challenges to Horizon?
No, I think I said in my statement, one of the problems was that the allegations against sub-postmasters were often very different. We had allegations of people taking money directly from the post office till, and there's one case where they were allegedly, according to one of the other witnesses, paying their staff directly from sub-postmaster's bill. Other cases, we had people who pleaded guilty and admitted that they were paying off the retail side of their business from post office funds in the hope that they would repay it. We had other cases where people were actually, when people wanted to withdraw money, they were typing in their PIN numbers, and it would fail first of all, and then they would type it in again and get the funds. And the allegation was that the first one would be pocketed by the sub-postmaster. So we were dealing with a whole different type of offending. And so, yes, there were cases where people were alleged to be short on their funds, but there were other types of offending as well. And so what we were looking at didn't fit a single Horizon bug. Now, obviously now we know that there are several types of Horizon bug, but that simply wasn't our state of knowledge at the time when we were reviewing it. And the second site report came in and said there was nothing systemic.
Is it right that you would occasionally attend the weekly hub meetings, later bi-weekly meetings on behalf of Cartwright King?
Very occasionally. I would do it when either Andrew Bowles or Martin Smith weren't available.
And roughly how many times did you attend? Can you recall?
I'd imagine you could count it on one hand.
Did you ever hear of any issues raised at those meetings that you thought required post-conviction disclosure or further disclosure review?
I don't think so, no.
Could we have on screen, please, paragraph 108 of Mr. Bowyer's statement, please? That's page 31. Apologies if I've given the wrong page reference there.
Paragraph 108 is page 23.
Yes, thank you, sir. My apologies. Bear with me for just a moment. It's page 31. It's paragraph 155, please. You say here, the reality is that there may be grounds to criticise the way that Cartwright King conducted the Post Office Limited prosecutions. However, they did fulfil their role as external lawyers in calling to a halt the prosecutions.
Attention, please. Attention, please.
Just rereading that sentence, and that
Yes.
first sentence, the reality is that there may be grounds to criticise the way that Cartwright King conducted the Post Office Limited prosecutions. Did you recognise at the time the Cartwright King review was set up that there may be grounds to criticise the way that Cartwright King conducted Post Office prosecutions?
Yes, I think when I was reviewing cases and when I was actually speaking to the people more involved, it became apparent as to how it was being done. And yes, I had concerns.
And at what point into the process did you have concerns?
Really, during the review, the SIF process, when we were reviewing cases. You have to remember, we were reviewing a lot of cases that weren't Cartwright-King, but they went back quite a long time.
At the time, did you recognise the risks inherent in Cartwright-King, and this phrase has been used a number of times, marking its own homework?
Well, yes, because that was addressed at a very early point. Especially, we had a conference with Brian Altman in his chambers in September, I think, 2013, and that point was addressed there and then. But I think it was felt that the Cartwright-King barristers actually hadn't prosecuted the cases themselves, and B, this was the fastest way of getting the job done.
That statement can come down now, thank you. I'd like to ask you next, please, about what happened in relation to cases in Scotland and Northern Ireland after the publication of the Second Sight interim report. Can you help with what was done by the Post Office or by Cartwright-King, if anything, to inform the Crown Office and Procurator Fiscal Service in Scotland and the Public Prosecution Service in Northern Ireland that Second Sight had been instructed to conduct their review in 2012?
I can't know.
There are documents the inquiry has to suggest that Martin Smith from Cartwright-King was involved in discussions with the Crown Office and Procurator Fiscal Service and BTO solicitors, to whom you referred yesterday, about the interim Second Sight report towards the end of July 2013.
Yes.
There are also documents to suggest that Simon Clark and Martin Smith attended meetings with BTO solicitors and the Crown Office and Procurator Fiscal Service about Horizon in September 2013. Did you have any involvement in those discussions?
No, I had no involvement in those discussions. They did certainly at least one trip, possibly more, to Scotland and BTO. I did speak to BTO on a couple of things. I think there's some email correspondence between me and one of their solicitors, but I didn't actually have any direct influence on the Scottish prosecutions.
Was there any consideration given to the impact of the interim Second Sight report on disclosure duties on prosecutors in Scotland and Northern Ireland by Cartwright-King?
I don't know.
As part of the Cartwright-King review, and that specific review and process, were Scottish and Northern Irish cases reviewed by Cartwright-King?
I don't think we touched the Scottish and Northern Irish cases.
Were you aware of a similar review exercise taking place in Scotland or Northern Ireland?
I wasn't.
Does it follow from your answers that you can't help with whether Cartwright-King notified the Crown Office and Procurator Fiscal Service or the Public Prosecution Service in Northern Ireland of its review exercise?
I don't know.
In 2014, you appear to have been asked by Jarnell Singh to look at a Scottish case, the case of Elaine Duran. Could we have on screen, please, the email which refers to that? It is POL 00333 This is an email chain which you're not part of, but we see your involvement in the case is referred to in this top email from Jarnell Singh, dated the 8th of October 2014. Before we look at that, just to put this in context and look at some of the one of the earlier emails. If we can look at page 2, please. about 2/3 of the way down the page, there is an email dated the 19th of September 2014 from David Oliver to Chris Ojard, copied to John L. Singh, among others. And it says this, subject Duran case. Chris, I wanted to bring one non-scheme case to your attention and check you are content with the suggested approach. The case in question relates to Mrs. Duran, deceased. The case was one of the original cases raised by MPs but did not apply for the scheme. It is an old case, 2004, and relates to an unsuccessful prosecution brought by the police in Scotland. Mr. Duran has written to Paula raising this case and criticising the Post Office's handling of it, and his MP has, with James Arbuthnot, sought a meeting with Paula to discuss the case, which James is chasing a response on. The case has been looked into by the Crown Office in Scotland, and Post Office has been in contact with them via BTO. John L. has previously dealt with this. Last correspondence I've been able to find internally, 14th of April. Then there's proposed next steps. And we can see over the page, John L. to contact BTO for any further and more recent correspondence. Subject to that, contact Crown Office to understand their views on the case and what has been provided to Mr. Duran. I will draft a holding reply to go to James. So that sets out some of the background to the case. Does this help refresh your memory at all as to how cases in Scotland were being looked at or reviewed, the references in that email?
No, I'm afraid it doesn't. I had very little contact with Scotland.
Going then to page 1, John L. Singh's email of the 8th of October 2014. He says, Belinda and Angela, as you know, Counsel Harry Bowyer of Cartwright King reviewed the information which Scottish police were able to provide in this case. It would appear this was limited and most probably not all the information that was provided to the Procurator Fiscal. This was not a poll investigation. However, if it is now to be investigated under BAU, it is my view and advice that any findings and further evidence discovered should be supplied to Harry Bowyer in order that he may review it. This would ensure Poll has the protection of being able to say the findings have been independently considered by external senior barrister. Was this common, John L. Singh asking you to take a look at individual cases?
There would be occasions. There would be occasions he'd ask me to look at cases. There'd be occasions he would ask me for advice on little issues. Yes.
And this appears to be on a sort of ad hoc basis rather than as part of the review process. Is that right?
Yes. I mean, we got contacted if they had questions outside the review question process.
Was it common for you to be asked to look at Scottish cases?
Well, not terribly, because, of course, Scottish law is different and I'm not qualified.
Did you feel able to advise on this Scottish case?
I don't recall this Scottish case, but the email suggests that the information was limited.
Were you aware that John L. Singh saw the purpose of asking you to look at cases in this way as being that the Post Office would have the protection of being able to say it had been reviewed by an external senior barrister?
I wasn't aware, but I would have been able to guess at it, yes.
That can come down now, thank you. At paragraph 106 of your statement, you refer to Cartwright King's involvement in drafting a new prosecution policy for the Post Office. Recognising that you say you had little to do with that side of things, what was your understanding of the policy in terms of its geographical remit, particularly thinking about Scotland and Northern Ireland?
I would have assumed that Simon would have been drafting it for England and Wales.
Can you help at all with whether the procedure in Scotland and Northern Ireland was viewed in the context of possible reform of Post Office Limited's prosecution policy? Was it considered at all?
Well, I don't think I had any role in that particular review process.
Could we have on screen, please, POL 00333-527? The top two emails here are from April 2015 and are between you and Laura Irvin, who was a solicitor with BTO solicitors in Scotland, the external firm who advised on post office cases. It appears from your email to, just scrolling down a little, please. Your email there, Laura at the top, Harry Bowyer at the bottom. It appears from this that you were looking after Martin Smith's emails whilst he was on holiday, and that was why you were in email correspondence with her. Is that right?
That would be right, Miss.
And starting with Miss Irvin's email of the 26th of March 2015, please, at the bottom of the page. Her email to Martin Smith. She discusses a Scottish case and appears to be trying to establish what the progress was on a Horizon expert report. Is this a reference to the attempts which were being made to find another expert
Yes,
at the
I think
time?
so.
And then at the penultimate paragraph of her email, she says, I have been provided with various pieces of information about the progress with the Horizon expert report, mostly by you, but that the last I heard from John Scott was that there was a report from Deloitte that may negate the need for an expert report. However, I got the impression from you yesterday that it didn't tick all the boxes. It would appear from this that BTO solicitors had not been provided with the 2014 Deloitte report. Would you agree on a reading?
Well, it looks like it, yes.
Your reply is above. And you say, Laura, Martin has me looking after the emails. The Deloitte report does not tick all the boxes, and we would prefer to be given a clean bill by the experts who are in the process of being instructed. They will be in no position to report in the timescale of this case. 2 points arising from this, please. First, you don't mention here your reaction of shock to the revelations in the Deloitte report about remote access, do you?
No.
Can you help with whether that issue of remote access was raised with BTO solicitors following Cartwright King's receipt of the Deloitte report?
I don't know, because the main contact between BTO was Martin, and you can see from this email, I was only stepping in while he was on holiday.
Second, you appear to be suggesting that any expert report would be giving Horizon a clean bill of health. Was that your view at the time?
Well, that's what we thought was going to happen, yes.
Why were you so sure of that?
Well, again, it was the second site report with no systemic problems. And so as far as their report was concerned, we thought we would get an expert report that would show that it was fundamentally sound and the evidence could be relied on. If the expert report had come back and said it couldn't be relied on, then that would have been the end of prosecuting.
That can come down now, thank you. In an email chain we looked at yesterday from August 2012, you referred to cases raising Horizon issues being likely to become more numerous as the bandwagon picks up speed. Why did you use that expression, bandwagon?
Yes, I think the inquiry is attaching pejorative terms to it. There are popular themes in criminal law and popular defences that arise. There have been bandwagons that I've joined when I've seen that a defence seems to be working. I will leap upon it. But no, as far as this was concerned, when Horizon became an object that looked as though it was being challenged, more and more people would actually take a look at it when they got a post office case in. It's common sense. But I don't see that the phrase bandwagon is in itself pejorative.
We needn't go to the documents unless you wish to, but bandwagon was an expression which was used by you in 2 advices relating to post office prosecutions,
Yes.
given after the publication of the interim second site report. You referred yesterday to the interim second site report being a shock moment.
Yes.
Did it not therefore make you more wary about making the kind of assumptions which underpin the use of the language Horizon bandwagon?
I don't think so, no, because you can join a bandwagon that is perfectly proper. There are occasions when the reason people are all heading in the same direction is that they've got a valid cause. But as I said, I don't find the term bandwagon pejorative.
There is one further document from yesterday I'd like to go back to briefly, please, for a point of clarification. The reference is POL 00293276. This is the 13th of January 2020 letter about continuing the relationship between Cartwright King and Post Office Limited. Going to page 2, please. What we looked at yesterday was that point 3 with reflections on past setup and relationship. But just looking down a little to the proposal here, the proposal being made in January 2020 was that Cartwright King would provide Post Office Limited with, there's a number of things listed there, but at point 4, the designated on-call lawyer shall be Simon Clark, Martin Smith or Harry Bowyer, but most likely Simon Clark. Can you help with why, after you left Cartwright King, some 4 years afterwards, you were being put forward as a potential on-call lawyer?
I wasn't sure as to what was going on here. What happened after we left was effectively we took the Post Office Department, myself, Martin and Simon, and so Andy Cash used to continue to call us up to see what was going on. And Post Office wanted this facility. By this stage, we weren't terribly keen on doing it because, of course, we'd had the civil case and seen Mr. Justice Fraser's judgments in the two issues that he decided.
Did this proposal come to fruition?
No.
That can come down now, thank you. Just one final point from me. You've said in your statement at paragraph 65 that the Post Office was an enormous client, even for a firm the size of Cartwright King. As you sit here today, do you think that the importance of Post Office as a client to Cartwright King influenced, whether consciously or subconsciously, the way you approached your advice and your ability to advise impartially and independently?
Yes, I think it must have. When we actually pulled the plug on the prosecutions after the Clark advice, it was worrying as to how our bosses at Cartwright King would take it. And it was, it was a big moment telling Post Office that they could not rely on their expert and they should stop prosecuting.
So those are all the questions that I have. There are some questions from core participants. Those I know about are Mr. Henry, Mr. Maloney and Ms. Oliver. There may be and Mr. Jacob as well. And I think that's it. In terms of order, if we can start with Mr. Henry, please, sir, then Mr. Jacob, then Mr. Maloney, and then Ms. Oliver. Is that
Certainly.
acceptable to you?
Yes, of course.
Thank you, sir.
Mr. Bowyer, so in a nutshell, you weren't happy with Mr. Jenkins's independence, so you decided to draft a generic pro-prosecution template for him.
No, that's not true.
Well, you were trying, you said, to be fair to the defence, and just coming to an expression that you used yesterday, that this statement would give the defence a windmill to tilt at. Tilting at windmills in contemporary parlance, Mr. Bowyer, is typically understood as attacking imaginary enemies or evils. Is that what you thought the defence were doing? That Horizon was impregnable and that their complaints were imaginary?
Well, at the time, we thought, and our instructions were, that Horizon was robust.
So is the answer to my question yes?
No, the answer to your question is, as far as the statement was concerned, it was meant to give something that the defence could, A, take a look at, the previous cases where the challenges were put in, so that they actually had somewhere to go, so they didn't have to start from scratch. Your question is unfair.
No, it's not unfair. It's entirely fair because you use the expression tilting at windmills, and I suggest that it reflects your overconfident, if I can put it neutrally, your overconfident approach to the issue.
No. Well, we disagree.
That the defence were on some sort of quixotic, unrealistic and ineffectual exercise of challenging, how dare they, the Horizon system.
Well, as I said, the idea was to actually give them an opportunity to make something of it. At the time, we had nothing to suggest that the Horizon system had any faults to it. Now, I can understand where you're coming from, because you're looking at this from 2024.
Don't presume to understand anything from my point of view, Mr. Bowyer. Let's go on to a document which is POL 000-96997. No need to get it up. You'll remember it. It was put to you yesterday. But you refer to defence inquiries as a fishing expedition. Did that reflect your view about defence requests for disclosure in relation to Horizon?
Some of them, certainly.
And your prediction, 2nd of October 2012, my view is that most challenges to the Horizon system should now vanish away before the trial. Were you taking, Mr. Bowyer, effectively a blinkered approach?
And I can see that particular comment hasn't aged well, but no, I don't think so.
Right. Can we turn, please, to POL 000-66807, please? This is your response to Mr. Altman's review. And could we go to page 3 of this document? And let's concentrate on Romans 7. Whilst this system is still in its infancy, there are issues that should be dealt with as soon as possible. A, an expert to replace Gareth Jenkins must be identified and instructed without delay, as almost all of our cases depend on the integrity of Horizon, even if only to the quantum of thefts. We need to have an expert to say that the system is sound, and whilst there are and have been glitches, the system and its product are sound. Does that not show that the intention was not for the expert to be objective, but rather to reach the conclusion instructed by Cartwright-King?
Well, no, I don't think so.
We need to have an expert to say that the system is sound, and that whilst there are and have been glitches, the system and its product are sound. Time is of the essence, as there are cases in the system that will be compromised without such evidence. This is old ground, so I will not go over it again. And this was essentially, was it not, the idea that the expert inevitably would say that the system was robust. A dangerous assumption on your part, Mr. Bowyer.
Well, if the expert said the system wasn't robust, it would have created problems for us, and we would have ceased to prosecute. But at the time, our instructions were that it was robust, and Second Sight had found nothing systemic.
But they had found disturbing issues concerning 2 bugs and also other deficiencies in the way in which the postmaster's complaints have been dealt with. Could we go to subparagraph B? The product of the hub meetings should be collated and assessed Much of it is raw rumour, but it needs to be investigated so that we can dismiss it as that. Again, does this not reveal raw rumour investigated so that we can dismiss it? Does this not reveal institutional bias on your part, too close an alignment with your professional and lay client?
Well, I don't think it does, no.
Other material may well point to genuine flaws in either the Horizon system or the use of it by Post Office staff, and needs to be addressed both to fix the flaws and be assessed as to its potential disclosability. How could flaws in the Horizon system, genuine flaws, be only regarded by you as potentially disclosable?
Well, again, this particular paragraph shows that I'm looking at the disclosability.
Don't you think that it ought to have been slightly more emphatic, or would that not have been unpalatable to the client? If there are genuine flaws, they must be disclosed.
Yes, you would be right.
Right. So were you trying to sugar the pill?
No, I'm afraid if you point at clumsy English, it doesn't mean that my intent was to actually make things palatable to the lay client.
Miss Price has taken you today to a Scottish case where you were trusted by Jarnail Singh to review it. The case was called Doran. She faced embezzlement charges of over £7,000 and was acquitted. And she said all she'd done was to follow instructions on the screen. In other words, she was not dishonest. She was only following the instructions that Horizon had given her. Do you remember the case now?
I don't remember it, no.
Well, I don't want to ambush you, but it seems you advised on non-disclosure.
You may well be right if I take it from you.
Let me just ask you now to in the mediation scheme and disclosure issues, do you accept that quite a lot, and the document I'm going to take you to doesn't actually refer to this, but a number of the issues in the mediation scheme, a substantial minority of these applications contain complaints about the behaviour of Post Office investigators?
Yes.
And you were against the reports that those investigators had compiled being disclosed, weren't you?
I was against some of the working documents being disclosed, yes.
Right. Well, let's go to POL 00301427.
While that's being brought up, just so that I can clear my mind, the actual criminal Doran case was long before your involvement, as I understand it, and you became involved because of the potential review of that case in the mediation scheme. Is that correct?
I think so. It was a Scottish case. I've got no recollection of it.
No, I appreciate that, but given that your involvement was, I think, 2014,
yes,
and the actual case was about 10 years before,
yeah,
it seems to be the only logical explanation.
Well, I'm not sure whether it's for the mediation scheme or whether for some sort of Scottish review. I don't know what it's
All right,
for.
so it's either the mediation or some review occurring in Scotland.
Yes.
Fine, all right.
Thank you, sir. While that's been brought up on the screen, POL 00301427, but the fact that somebody was being tried on Horizon data, the case was brought on Horizon data, the charge was dishonesty, and they had been acquitted. Did that not strike you as disclosable in other cases?
I don't think I considered it. I don't know.
Right. So can we go to your email in this email chain, please? And we start off with, I agree with Harry's advice. Can we scroll down, please? And can we scroll further down, please? And then we have that. Yes, Roman 2, please. This is your advice. The views of the prosecuting lawyers at an early stage of the proceedings on the strengths, weaknesses of our case being exposed to defendants and their defence teams. These were your concerns, and that was the concern that I've just read out. This could create problems should we recommence prosecutions. In extreme instances, we could become witnesses in our own cases. An obvious example is the case of Chowdhury, Wasim Abbas, in which neither the Post Office investigators nor the poll systems cover themselves in glory. I'm sure that our mutual client, POL, does not want a document in the public domain that provides a route map to how to attack us where we are most sensitive. Ms. Bowyer, isn't that precisely the purpose of disclosure under the CPIA, that the material might be capable of undermining the prosecution case or assisting the defence?
Absolutely.
Right. So why did you say, I'm sure that our mutual client does not want a document in the public domain that provides a route map to how to attack us where we're most sensitive?
Because as far as that's concerned, it should be considered in the context of each case.
Right. And can I just ask you to consider this? The Horizon bandwagon, and you say that that wasn't pejorative, and so be it, but those two advices that Ms. Price referred you to were dated the 2nd of September 2013 and the 5th of September 2013. Here we are involved in the mediation scheme. Do these views not reveal a somewhat jaundiced approach which might have affected the way in which you were performing the SIFT?
I don't think so, no.
Well, my conclusion are two matters. The first is, and they're both concerning clients represented by Messrs. Hodge, Jones and Allen, who instruct me. One is Mrs. Kathleen Crane. You reviewed her case in November 2013, and you stated, in my opinion, and we need take no further action upon this file. And so, therefore, the safety of her conviction was not reviewed as a result of that advice, and she was only cleared in the Court of Appeal in January of this year, having suffered years of anxiety, having, of course, lost her occupation and having to go into a caring profession where she was having to disclose her conviction, of course, to the Disclosure and Barring Service with every employment application. Have you read the judgment in her case?
I'm not sure that I have.
The Court of Appeal stated at paragraph 22 that they were satisfied that the Post Office was correct in conceding the matter, and they continued to state, this is indeed a Horizon case in which the reliability of Horizon data was essential to the prosecution, and there was no independent evidence of the alleged or any actual loss. And then they continue, the applicant in interview explained why she had acted as she did and asked for the reliability of Horizon to be investigated. She and her husband paid the full sum said to be missing. She was nonetheless prosecuted. No relevant investigation was carried out and no disclosure was made of the known concerns about Horizon. Mr. Bowyer, how on earth did you come to the conclusion that no disclosure was merited in her case?
I'm afraid I don't know.
Mrs. Misra's case, which you were aware of, but of course was dealt with, I think, by your colleague Simon Clark.
It was, yeah.
She needed to be told in the clearest terms, you would agree, that the expert witness in her trial was discredited. You would agree with that?
I would agree with that.
And yet that didn't happen, and she wasn't even given what I suggest would have been the inadequate disclosure of merely the Second Sight report or the Helen Rose report. Now, I realise it wasn't your case, Mr. Bowyer, but you were part of the team.
Mr. Henry, I think he has said it should have been disclosed. That's good enough for me.
Thank you, sir. Those are my questions.
Thank you. I think we have Mr. Jacob next, is it?
Thank you, sir. Yes, Mr. Bowyer, I want to ask you some questions about the mediation scheme.
Okay.
And you've set out in your witness statement at paragraphs 109 through to 140 your involvement in the Cartwright-King reviews
Yes.
of the mediation responses. Perhaps we don't need to go to this, but one of your responses in the case of Walters, who was one of our clients, at paragraph 117 of your statement, the response is, dangers to Post Office Limited. This case did not result in a prosecution or a conviction. It is unlikely to affect any criminal cases conducted by Poll, past, present or future, unless some concession is made about the integrity of Horizon, which from the robust Poll response seems unlikely. Do you accept that it was Cartwright-King's position to ensure that nothing came out of the mediations that could result in damage to Post Office's position that the Horizon system was a robust system, or could lead sub-postmasters to have any evidence upon which they could cast doubt on the integrity of the Horizon system?
Well, as far as we were concerned, obviously you've seen from the papers that my position was we didn't want criminal defendants in there. But yes, I mean, as far as we didn't want unwarranted concessions to be made, that the Horizon system may have been may have not been robust, because that was not what the evidence actually said at the time. I concede totally from our point of view, looking at it from 2024, that has not aged well.
Well, exactly. And in July 2012, you wrote your advice in the case of Wiley.
Yes.
Where effectively you said that Post Office was in a firefighting situation.
Yes.
Fujitsu should consider themselves also to be in that position.
Yes.
And that, to summarise, there would be severe recriminations for the business if Second Sight uncovered any systemic problems. Is that right?
Yes.
So what you were saying is, don't do anything that could result in a concession being made that Horizon is not robust.
I can see how you're formulating the question, but the intent was I didn't want any unwarranted concessions made that the system wasn't robust.
And what's an unwarranted concession?
A concession merely to make the mediation go more smoothly.
Are you aware, and I'll give an example of a case of one of our clients, Mr. Peter Holloway. He attended a mediation in November 2015. Presented his case to the Post Office representatives with the mediator present. He says the mediator told him there was a good chance that the Post Office would agree to settle his case and that there might be a reasonably significant sum. Post Office representatives thought about it. The mediator returned to Mr. Holloway at 3 o'clock in the afternoon and said, "I don't know what to say. They're refusing to even make you an offer." The mediator told Mr. Holloway that the Post Office representatives had told him they'd been sent to the mediation with instructions not to settle at all. Were you aware that Post Office representatives were attending mediations with instructions to maintain in the mediation that Horizon was robust and that there should be no settlement, or if any settlement was made, it was simply to be a token?
I wasn't aware, no.
Are you aware that anybody in Cartwright-King advised that what you had advised in relation to the Wiley case should feed through into the conduct of the mediations?
Again, my main role was to advise on various documents that were going forward to the mediation. How the mediations were carried out, we had no role in.
You understand, of course, that the function of mediation is that there should be some concession.
I totally understand that, and to an extent that's part of the danger.
Can I then move on to another topic? I want to ask you about Brian Altman, KC, and his terms of reference. And we will need to put a document on the screen for that. It's POL 0002191. Just wait for it to come up. So here we have Mr. Altman's observations on his terms of reference for making a presentation in relation to the Post Office Board. Can we scroll down, please? And can we scroll down to B? So scroll down further. Right. So B, I understand that I'm to meet and report to the board. And then if we move to scroll down further. So point 2, on the efficacy of past prosecutions, including the preparation and conduct of past prosecutions. And then if we move down to footnote 4 at the bottom of page 3, please. And if we could maybe highlight, we've lost it. Footnote 4, bottom of page 3. Thank you. So Mr. Altman says, it is for Poll and those instructing me to determine whether or not it is only the efficacy, i.e. effectiveness of past prosecutions, etc., that I'm being asked to consider with the board, or in fact the potential safety of past convictions following Poll prosecutions, i.e. whether in my judgment the Court of Appeal is likely to think that the conviction is unsafe. Now this follows on quite shortly from Simon Clarke's advice, where he said that Gareth Jenkins, the architect or one of the architects of the Horizon system, his evidence was tainted and unreliable. Did you think at this point that senior counsel ought to be advising on the safety of the convictions in light of the apocalyptic revelations concerning Mr. Jenkins?
Well, as far as the convictions were concerned, most of the convictions were guilty pleas, and
Sorry, I didn't hear you.
Most were based on guilty pleas, and most had admissions in interview to some sort of false accounting or whatever, and the position at the time was, as I said, Second Sight came back and they said that there were no systemic faults in Horizon. They produced the 2 bugs that they produced. And so when we stopped the prosecutions, it wasn't on the basis that Horizon was unsafe, because we didn't know that it was unsafe. We felt that nothing systemic had been found on it. We stopped it because we felt that the witness Gareth Jenkins was unreliable. And so the catastrophic findings later that Horizon had multiple bugs in it only really came to light in 2019 in the civil case in front of Mr. Justice Fraser. And certainly at this particular stage, as you know, a guilty plea is a very difficult thing to appeal in the Court of Appeal. This case, of course, it happened because these cases were, and I don't dispute it at all, these cases were an affront to justice because people had false accounted because they were met with massive figures.
What about, if it can be inferred, surely it must be inferred from the Gareth Jenkins position, that there had been multiple failures of disclosure in numerous prosecutions over the years?
Well, there had been failures of disclosure.
I'm sorry to intervene, but this started as a question about Mr. Alton's terms of reference.
All right.
With respect, Mr. Jacobs, I don't think Mr. Bowyer is the person to ask about that. Mr. Alton was instructed, I believe, by Womble, Bond, Dickinson, or whoever, and very much having an input from senior post office lawyers. I don't think Mr. Bowyer was involved in his instruction.
Of
and
course.
if he was, I apologise, but I don't think he was.
I'll move on to the next document, which is POL 000. Sorry, POL 00. 21980. This is in relation to the efficacy point, and I just want your comment on this. And I know that, that this isn't an email that you saw at the time, but this is Womble Bond Dickinson responding to Mr. Altman's footnote. And what is said here is, please find attached two separate terms of reference for Brian Altman QC as amended in response to his observations document, which I also attach for ease of reference. Please note that Paul needs to decide on the issue which he's asked to report to the board on the efficacy or safety of past prosecutions. See footnote 4, page 3, which you've just gone to, of Brian's observations. Simon's and my view is that he shouldn't report on the safety of past convictions for two reasons. Firstly, this is likely to involve a more significant analysis of lots of cases, thereby delaying his report. And secondly, and potentially blurs the boundary between BA and CK's respective roles. Now, you've said in your evidence that you thought that Bond Dickinson's knowledge of the criminal law was somewhat sketchy. Is that right?
That was my opinion at the time.
What do you have to say about the advice that Bond Dickinson were giving Post Office in relation to Brian Altman's query about whether he should be advising on safety?
Sorry, what was my opinion then on that?
Yeah.
I wasn't aware that he was being instructed at the time, or they were considering him looking at the safety of the reviews. Our instructions in the SIF review was not to look at the possible, look at the potential of appeals at the time. It was just as to whether the stuff would be disclosable or not.
And do you think, following the Simon Clark advice, that Post Office, in light of the potential for miscarriages of justice, ought to have sought advice on the safety of convictions as a matter of urgency?
I'm sorry, Miss. I just don't think this is appropriate for this witness. These questions can be asked of the people who instructed Mr. Altman.
Thank you, sir. I'll move on. I don't have any further.
It's on. Yep. Thank you. I'm grateful to the stenographer. Mr. Bowyer, I'm going to ask you about Gillian Howard. She's one of the 78 core participants I represent, all of whom were prosecuted and convicted, and all of whom had their convictions quashed. And I'm going to ask you about disclosure in her case and why you didn't advise disclosure on review, but I'll take you to your advice in doing so that you can see why you didn't disclose, which will hopefully help when you're answering questions. Okay.
Yeah.
Now, she falls into the category of most cases that you've just described to Mr. Jacobs, that is to say, a guilty plea and an admission to false accounting.
Yes.
She was interviewed under caution on the 8th of June 2010, following an audit that revealed a shortfall of some just shy of £46,000. And then, so that's the 8th of June 2010 for the interview, and then by letter to Post Office on the 7th of April 2011, and that date is important, Mrs. Howard offered a guilty plea on a proposed agreed basis. Does this jog your memory?
I remember the case. I discussed it
Thank you very
paragraph
much.
75.
I'll shortly take you to your advice, but just to finish the background details, as it were, to start with. She pleaded guilty on the 26th of April 2011, having indicated or offered the agreed basis of plea on the 7th of April of 2011. And on the 26th of May, she was sentenced to a 6-month community sentence.
Yes.
Just for completeness, at the Court of Appeal, Post Office accepted it was an unexplained shortfall case. Evidence from Horizon is essential to Mrs. Howard's case. No ARQ data was obtained at the time of the criminal proceedings. No evidence to corroborate the Horizon evidence. No investigation into the matters raised by Mrs. Howard in interview. And no examination of the numerous calls that she'd made to the helpline. In fact, she'd made 22 calls to the helpline saying that she was having real trouble balancing with Horizon, and none of the other staff at the branch was interviewed. And there was no proof of an actual loss. So a paradigm Horizon case in many respects.
No, I accept that.
Indeed. So could I ask that we look at your advice now, which is poll 30-21207. I'm grateful. And if we could go straight to the end, to paragraph 27. And there we go, thank you. Where you say, in conclusion in relation to this case, Mr. Bowyer, this is an extremely worrying case. It's only through good fortune, sensible prosecution counsel and a sympathetic judge that we are not going to have to disclose material which would cause Post Office Limited a great deal of embarrassment. Could we please go back up the page now to look at the specific circumstances of this case, and I think back to paragraph 15. Sorry, and yes, and above that, please, if you could go back to the previous page. I'm sorry. Keep going. And and just slightly further, please. Going up, and going up, and there we go. Paragraph 10. Thank you. So paragraph 10 relates how Mrs. Howard, following the audit, said she'd like to arrange a PACE interview. She was told of her rights. She produced a typed statement and article from the Grocer magazine relating to glitches in the Horizon system. And her prepared statement and note also complained of lack of support from Post Office and says that a series of errors were made, inference being she wasn't properly trained. But the contents of her interview are in the next paragraph. She's interviewed on the 8th of June, read out a prepared statement, said she'd not taken any money. She used to help her husband with the cashing up. She'd experienced problems from 2008 after her husband was taken ill. She employed 2 staff. When her husband was ill, she struggled to balance the accounts from the outset. She was never sure that she was completing the monthly balance correctly and simply put in the figures that Horizon displayed to balance. She was aware that the figures she was entering were inflated and that losses were increasing, and to hide the mounting shortages, she began to suppress business deposits from a local bus company. Carrying on down, she felt that an employee might be responsible for the losses. I won't name the employee for obvious reasons.
Of course.
She was concerned about her employee's sons visiting the shops to borrow money. She had less than a week's notice about the transfer to Horizon Online. Finally, she was aware that what she was doing was dishonest and had not financially benefited from any of the missing money. So she expressed concerns about Horizon as the Court of Appeal noted. If we could then go down to paragraph 13, which is just further down, you find other considerations. It became apparent, and this is an email from Helen Dickinson dated the 10th of February 2011, and that date's important because it's some 2 months before she enters her plea in April 2011. After Mr. and Mrs. Howard were suspended, that those who ran New Mill Post Office continued to employ the employee and also took on one of her sons. The Post Office continued to suffer small, unexplained losses, including cash being taken from a charity box in the secure area. It transpired that the employee had a key to the secure area that the new management were unaware of, and the employee's son has admitted theft from the charity box. And essentially what happened to that information, that it was kept under review, it wasn't disclosed, and there's a green post-it note attached to an email of 5th of April 2011 talking about scrapping the sensitive, unused items. If we could go down further to paragraph 18, please, the culmination of all of this is item 17 on the non-sensitive unused schedule dated 4th of April 2011, served on the defence by letter on the 11th of April 2011, so that's 4 days after the indication of the offer of an agreed basis of plea. when in fact this information was available some 2 months before the agreed basis of plea. There's an entry that reads, email from New Rolls personnel regarding incident at New Mill. Now that's the email that refers to the thefts by the employee's son, but it's really quite a cryptic reference, isn't it?
Yes.
For anybody looking at an unused schedule in those circumstances. So Mrs. Howard had pleaded guilty, but she said in interview that she always felt she wasn't completing the monthly balance correctly. She'd inflate the figures to make them balance. She brought an extract from the grocer, which made her wonder if she was wholly responsible for the shortfall problems, and money was going missing from the tills, which could have been another employee, or her giving credit, which she should not have given, was in fact what she said. We know that, in fact, that information about the employee's son was available 2 months before the agreed basis of plea was offered, and the schedule reference in April, just in fact after the agreed basis of plea was offered, was quite cryptic. So, after that which Mrs. Howard had said in interview, should the material about the employee's son not have been disclosed straight away, as soon as it came to light, 2 months before any offer of plea?
Yes, I think it should have.
The disclosure reasonably assisted Mrs. Howard's case in interview and supported her veracity.
Yeah, no, as I say in my statement, I think I got this particular advice badly wrong.
Thank you, Mr. Bowyer. Indeed, you do say that in your statement, don't you, at paragraph 75, that, and I was going to go on to that, but just before we get to that, she was entitled to know that that information when she was considering her plea and when she was being advised by her lawyers as to her plea, wasn't she?
You're absolutely right.
Yeah. And it should have been disclosed on consideration of the appeal as well, shouldn't it?
It should have been, yes.
Because it would have provided a basis for arguing that there was serious material non-disclosure.
Well, over and above the Horizon system, yes.
Absolutely.
Yes.
Now, but you took the view that it's my view that there could not possibly be an appeal against conviction based on the disclosure of the subsequent losses in the post office, bearing in mind the admissions in interview and the basis of plea.
Yes.
But that was for her to decide rather than you, really.
As I said, I think I got this advice wrong.
Thank you, Mr. Bowyer. And also, can I just ask you about the information about continuing unexplained small losses?
Yes.
Because they didn't stop at what the employee's son was doing, did they? They were unexplained small losses, which were not, as it were, only the theft by the employee's son.
I can't recall the details of the case that far, but I'm sure you're right if you say so.
But if we can assume for these purposes that in fact they were unexplained small losses, then they also would have assisted her case in interview, wouldn't they?
Again, I would have thought so.
Yeah, and really that should have been disclosed if they were unexplained small losses.
Yes.
And indeed, second sight report might well have been disclosed in those circumstances, given that it had, as it were, highlighted the difficulties.
As I've told you, and as I said in my statement, I didn't get this one right.
Can I ask you this? And it's important that I do ask you.
Yes.
Was this material not disclosed because, in fact, yes, it really would cause Post Office a great deal of embarrassment at a time when Post Office was already suffering a great deal of embarrassment?
I don't think so, no.
When you say you don't think so,
no.
was it a fact, either, I don't think a subconscious factor can operate.
Well, it may have been subconscious, but I mean, I like to think I'm a straight edge as a prosecutor. And, as I said, what overbore my mind in this particular one is that she was sentenced on her own basis, that there was, she wasn't responsible for the loss, and so therefore she was sentenced on her pleas, her admissions in interview and her guilty pleas.
Yeah, but this material, as you rightly concede now, should have been disclosed.
I certainly concede, yes.
And finally, just to expand slightly on a point Miss Price asked at the end of her questions for you. You were asked about the importance of the Post Office account to Cartwright King.
Yes.
Yeah. You said yesterday that you were pleasantly surprised when Cartwright King management did not push back on your attempts to rectify the position following the revelations about Gareth Jenkins.
Yes.
And even because you said even for a firm of the size of Cartwright King, post office was an important account.
It was an important account, yes.
One of the central aspects of that importance, would it have been the amount of income the account generated for the management of Cartwright King?
It generated quite an income, yes.
Yeah. And that's an important consideration in these circumstances.
I would have thought so, yes.
Yeah. Thank you very much, Mr. Bowyer.
Mr. Bowyer, can you remember whether, notwithstanding someone had pleaded guilty to false accounting, you nonetheless decided that the second site report should be disclosed?
In this particular case, I didn't. Some cases...
No, I appreciate that.
Some cases...
Go on, sorry.
Some cases where they pleaded guilty, I mean, one was always aware that in these cases there was a certain amount of coercion on a defendant when they entered their guilty pleas. And so some of these cases where they raised Horizon as an issue in their interviews, we did disclose the second side and the Helen Rose report. So it wasn't... I think in some of my cases I was too quick to actually not disclose when there were guilty pleas and full admissions in interview. But
right.
Yeah, in the main, as I said, we thought we were doing right at the time, and when our cases were reviewed, they were found to be sound.
All right, fine, thank you. Miss Oliver, can you give me a prediction about how long you are likely to be? Because I'm conscious the transcriber has been going for about an hour and 20 minutes now.
Yes, sir. I think probably about 5 to 10 minutes.
Can I ask the transcriber whether she would prefer 5 to 10 minutes more and then a proper break, by which I mean at least 15 minutes, or whether she wants a 10-minute break now?
It's fine to finish. I understand the transcriber is content to carry on and then have that break.
Thank you. Well, you're usually very accurate with your estimates, Miss Oliver, so I'm confident that you will be on this occasion.
Thank you, sir. I'll try and stick to it. Good morning, Mr. Bowyer. I ask questions on behalf of Gareth Jenkins.
Hello.
I want to ask you a little bit about the Simon Clarke advice and the aftermath. In that advice, as I'm sure you're well aware, at paragraph 37, Mr. Clarke advised that Mr. Jenkins had not complied with his duties to the court, the prosecution or the defence. But at paragraph 38, he stated that the reasons as to why Mr. Jenkins failed to comply with this duty are beyond the scope of this review. Do you remember that?
I remember that, yes.
And at paragraph 63 of your witness statement to this inquiry, I don't think we need to go to it, you indicate that that discovery and the implications of the Simon Clarke advice were plainly enormous, is your words. Do you remember that?
I remember that.
When you considered that the potential implications were so enormous, did you and your colleagues not consider it imperative to ascertain the circumstances in which Mr. Jenkins had come to give evidence in the prosecutions in which he was involved?
Well, as you know, I wasn't taking the lead in this, but as far as the bugs were concerned, my understanding was that the bugs actually came either from Fujitsu or Mr. Jenkins himself, and then they're not mentioned in any of the previous reports.
Do I take it from that inquiry as to the circumstances in which he came to give evidence was not something that was undertaken by Cartwright King, or at least not to your knowledge?
Well, as I said, I wasn't the lead on this, so not to my knowledge would be probably the best thing, but there are witnesses to come who will be able to answer that for you.
I'm going to ask you a few questions as to what you did, and if the answer is no, I didn't undertake that activity, then please do just say. Did you ask to see any of the written instructions that Poll or Cartwright King had given to Mr. Jenkins?
No, I didn't.
Did you seek to understand what Rachel Panter, who you described yesterday as a comparative baby, we've heard described as a paralegal, was doing in her conduct of these prosecutions for Cartwright King?
No, I mean, she was based in Leicester, and I assumed she was under the supervision of Andrew Bolse, who was there.
Did you ask any questions of Mr. Singh at Post Office as to whether Mr. Jenkins had ever been instructed as to the expert duties of disclosure?
I'm not sure. I think I was aware that he was in Misra around about this time.
Did you speak to him about his dealings with Mr. Jenkins?
No, I didn't.
And just on the topic of Mr. Singh, did he ever reveal to you any of the Horizon issues that he had been told about by Mr. Jenkins in the course of the Seema Misra prosecution?
No.
Did he ever mention, for example, that he had been told there was a locking issue in Horizon which caused transactions to be lost?
No.
That there were some 200,000 system faults recorded in the Horizon system? That Fujitsu maintained a known error log?
No.
All right, thank you. And a similar question, did you ever ask the question of any of the Cartwright King lawyers who dealt with Mr. Jenkins whether he had been instructed in respect of his expert duties of disclosure?
No.
Thank you. Did you ever become aware that in many of the cases that were prosecuted by Cartwright King, for example, the case of Grant Allen, Mr. Jenkins had not been provided with the audit data in order to examine what might have happened at the relevant branch?
No, I wasn't aware.
Were you ever aware of indications that Mr. Jenkins gave to Cartwright King that the analysis of that audit data would have allowed him to ascertain what the issue might have been in a given case?
I wasn't involved in the prosecution of any substantial case. I tended to come in when people asked me for a bit of advice generically.
And no subsequent investigation revealed those matters to you?
And I wasn't made aware by subsequent investigations.
Thank you. And finally, did you ever speak to Mr. Jenkins about the state of his knowledge and understanding of his role?
I never spoke to Mr. Jenkins at all.
All right. Thank you. Can we just look at one document, please? It's Poll 001 555. Have you seen this document before?
I don't know.
All right. It's dated the 2nd of September 2013. We've heard evidence that it was authored by a lawyer at Post Office called Roderick Williams.
Yeah.
But it appears to record conversations with your colleague Martin Smith of Cartwright King.
Yes.
If we can scroll down to the bottom, please. Thank you. On the right-hand side, in the box, the handwritten box, we see the second point down, the question, what were we doing to instruct GJ, which we take to be a reference to Gareth Jenkins. And in the left-hand corner, we see M. Smith and then a series of arrows. And the first one is, don't think he's ever been advised of his duties. Do you see that?
Yes.
Were those matters that Martin Smith ever discussed with you?
I don't think so, no.
Was there any recognition to your knowledge within Cartwright King at the time of September 2013, when this note was authored, that there had been a failure to instruct Mr. Jenkins as an expert witness, or at the very least that there was a serious question as to whether he had been instructed as to his expert duties?
Again, not to my knowledge.
Thank you. And it may follow that you were not party to any discussions of those issues within Poll either?
I don't think so, no.
All right. Thank you, Mr. Bowyer.
Pleasure.
So I think those are all the call participant questions, and now would be the time for the morning break, sir.
Thank you. Well, thank you, Mr. Bowyer, for your witness statement. for coming on 2 consecutive days to the inquiry. I'm grateful for your participation.
I'm blush.
So we'll now break off until 11:30. Is that
Yes,
a
sir.
generous 15 minutes? Yeah,
Thank you.
fine.
Good morning, sir. Can you see and hear me?
Yes, I can. Thank you.
Thank you very much. We're now going to hear from Mr. Smith.
Yeah, can I suggest, Mr. Blake, in terms of breaks, that we don't try and fit in a sort of short break between now and 1 o'clock, but rather we finish for lunch a little bit earlier and time the day thereafter, so to speak.
Absolutely. In fact, we've been speaking to the stenographer, and she has confirmed that she'll make a signal if we are going on for too long. But otherwise, we propose to carry on until lunchtime.
Yeah, okay.
I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you. Can you give your full name, please?
Yes, I'm Martin John Smith.
Mr. Smith, you should have in a bundle in front of you 2 witness statements.
Yes.
The first witness statement was taken in advance of phase 4 of this inquiry. It should be dated the 21st of November 2023. Is that correct?
Yes.
And if I could ask you to turn to page 34, the final substantive page.
Yes.
Can you confirm that that is your signature?
I can.
Thank you very much. In respect of this witness statement, can you confirm that it is true to the best of your knowledge and belief?
It is true to the best of my knowledge and belief, but there is a slight amendment I do need to make to this witness statement.
And can you assist us with what that is, please?
In paragraph 104 on page 27, I refer to an email which I've sent to Stephen Bradshaw and Mark Ford. The second sentence in that paragraph, could we change Mr. Ford had confirmed to counsel had confirmed. It was Mr. Ford I was writing to, and I think it was a different counsel who would have been in court, not Mr. Ford.
Thank you very much. That witness statement has the URN WITN 096801000. The second witness statement is dated the 19th of March of this year. Do you have that in front of you?
I do, yes.
Could I ask you to turn to the final substantive page? That's page 47.
Yes.
Can you confirm that that is your signature?
It is, yes.
And can you confirm that that statement is true to the best of your knowledge?
It is, yes.
Thank you very much. Mr. Smith, both of those witness statements will be published on the inquiry's website shortly. Thank you. You are a solicitor and have been since 1996, is that correct?
That's correct, yes.
You acted, I think, initially as a criminal defence solicitor.
Yes.
I think you were a duty solicitor, is that correct?
That's right, yes.
And before joining Cartwright King in 2006.
Yes.
And you were at Cartwright King until 2016?
Yes.
And I think we've already heard that you then subsequently founded a firm with Mr. Clark and Mr. Bowyer.
That's correct, yes.
And then you joined a new firm in 2020, is that correct?
Yes.
Whilst you were at Cartwright King, you were promoted to the role of senior associate, is that
That's
right?
correct.
Did you start as a junior associate or an associate or something else?
I think I was just a solicitor. I don't think there was a label attached.
Cartwright King acted in cases relating to the post office prior to its separation from the Royal Mail in April 2012. Do you recall how much earlier? We've seen, for example, documents from January 2012. Was it around then or before then?
I'm afraid I really can't recall. I think the partner in charge of the Derby office would attend court generally on an agency basis for the Royal Mail Group / Post Office Limited. much of the work was carried out, I believe, along those lines, just attending court to present cases. But there became a point when case files started to be sent into Cartwright King for advice, and I really cannot recall, I'm afraid, how much earlier than April 2012 that happened.
And does that go for your own involvement as well, that you can't be sure how much earlier than April you were personally involved?
I would certainly have appeared on occasions in court on an agency basis to present a case, but I don't recall when I first started preparing advices and doing something more than appearing on an agent. I know the two case studies that I was involved in, the advices were prepared prior to the split.
So you separate being acting as an agent and having full conduct of a case?
Yes, there's a difference between the two, in my view, yes.
And what is the difference between the two?
Well, acting as an agent, you attend court, you present the case in accordance with your instructions and you report back. Once we were asked to advise on cases, that's an entirely different situation. That is requiring a lot more knowledge in terms of the role of a prosecutor than just simply attending court to present a case at a hearing.
To what extent do you consider that you had authority to make decisions in a case once you had taken on that new role?
I think the situation was very nebulous to start with, in that certainly the two advices that I've seen recently, I wasn't clear who was ultimately making decisions, and I assumed that it would be going back to the head of the legal department to make decisions. We didn't, for example, know what post office prosecution policy was at that point. There were things that we didn't know. What yardsticks were we to apply in making the decisions? Yes, we could advise in the general, but ultimately those decisions needed to be made by someone within the organisation.
When you first took over, I think you've said in your statement that the old Royal Mail cases were just provided to you without any handover or explanation.
Yes. I don't recall any handovers. I think they just arrived. And Mr. Cash, who was the partner in charge of the Derby office, would simply allocate them accordingly, distribute them to whoever he wanted to deal with the case.
And you've said you didn't see the various policies in place. Did that position change over time?
Ultimately, Cartwright King was asked to advise with regard to amendments to a draft prosecution policy. So yes, we ultimately did see a policy, and I think Simon Clark, one of my colleagues, made suggestions with regards to the proposed amendment of that policy, and I think that was at the request of Susan Crichton, who was the then General Counsel.
And is that later in, say, 2013 onwards, or would that have been in 2012?
I believe that would have been after the publication of the interim second sight report, so in 2013, I believe.
And up until that point, you were working without any policies?
Yes. I think there became a point when Mr. Singh decided how he would like the advices set out, and we followed the instructions that he provided in relation to that.
We've seen your name in quite a lot of the documents, and the same names crop up again and again. Were you one of the main solicitors in the firm dealing with post office cases?
There were very few solicitors in the firm dealing with post office cases. There was myself based in Derby, Andrew Bolts a solicitor based in Leicester. There may have been others from time to time involved. And in terms of counsel, it was Simon Clark, Harry Bowyer. There may have been a couple of others from time to time.
If we take the 2012-2013 period together, is it likely that you were the solicitor who had the greatest conduct of individual cases?
I don't know, I'm afraid. I think the cases were generally apportioned between myself and Andrew Bolts in Leicester.
Thank you. We're going to come and see issues relating to decisions to prosecute, basis of pleas, etc. Were you able to make those decisions autonomously without reverting to the Post Office?
In terms of decisions to charge, the advice would be given to Post Office and Post Office would make the decision. In terms of bases of plea, I believe that it would have been the common practice to revert to the investigating officer to run it past the investigating officer if possible.
Who do you understand from the Post Office to have been providing instructions in the cases that you were acting in?
Prior to the separation, it would have been the Post Office Legal Department. And I suppose post-separation, it would have been the Post Office Legal Department, but the case file may possibly have come from an investigating officer directly, or it may have been that information was provided by an investigating officer.
And if you needed to consider whether to, for example, accept a plea or to make a charging decision, who do you consider would have been the relevant person to approach in that respect?
Well, a charging decision would have been put in writing and the file would have been returned back to Post Office in accordance with the instructions at the time. I can't remember the precise mechanism for the return of the file. I don't know who it went to, I'm afraid.
When you say the charging decision would have been made, though, who would it have been made by?
Within the Post Office? I'm not sure. I can't remember.
Is it that you can't remember or you weren't certain at the time?
I'm afraid I just... There could have been changes during this period of time because we've gone from having the Post Office as part of the Royal Mail Group and I believe files coming from Mr. Wilson to the Post Office splitting off from the Royal Mail Group and files being returned. They would have had formal advices on them and I cannot recall the changes to the processes and the personnel in terms of who would have been looking at those documents.
But if we're going to today look at 2012-2013
Yes.
period, who would you have considered responsible for making the ultimate decision as to whether to charge somebody?
Well, prior to the split, Mr. Wilson at the Royal Mail Group, and post the split, John L. Singh at the Post Office.
Thank you. I want to look at decisions relating to the public interest. Can we first please look at poll 0014148, please? This is an email of the 10th of December 2012, and it's from John L. Singh to yourself. And he says as follows: Martin, John Scott's the decision maker. I think that it's meant to read concurs with Counsel Will Martin's advice that it is not in the business or public interest to proceed with prosecution of Mr. Nimesh Patel. Marin, could you write to the defence and court of the business decision and have the case listed for a short hearing where prosecution counsel should be instructed that this agreed action must say to the defence and court is not connected with the Horizon system integrity and rather simply reflect the defendant's health and associated issues. Now, I think you've said in your witness statement that you don't recall this particular case. Is that right?
I don't recall this one, no.
But we see there reference from Mr. Singh to the business or public interest to proceed. What did you understand by the business interest?
Well, this was a private prosecution, and so a business conducting a private prosecution is always going to have an interest in whether or not the case should proceed. And certainly there's also a public interest argument in terms of whether or not the case should proceed.
And did you consider those to be separate interests or one and the same?
They can be entirely separate interests.
Can we please look at poll 00411347? This is a much later case. The case of Zen Elvins. And this is a charging advice that is written by you. If we could scroll down, please. We can see at paragraph 6 over the page a summary of what Mr. Elvins said about his case in interview. It says, Mr. Elvins made full and frank admission, explaining that he had discovered that it was possible to sell a postal order, reverse the transaction, and cash the postal order before the cut-off point every day at around 7 p.m. So it seems as though this isn't a Horizon case. This is a case of somebody admitting a way to manipulate the Horizon system. Yes. If we could scroll down, please, there is then a section entitled Discussion. And I'm going to read to you paragraphs 8 and 9. It says as follows. Whilst this case does not appear to contain an Horizon issue, I am concerned about the possible effect of commencing proceedings against Mr. Elvins, thereby putting a case into the public domain in which a suspect said, to be honest, there's so many little loopholes in the system that you kind of just find them. Sorry, if we could scroll up slightly. Thank you. We could scroll down now. Paragraph 9 says as follows. It says, my understanding is that Mr. Elvins was able to exploit a known weakness in the Horizon system. Whilst this is not an Horizon issue, to the extent that the system permitted the sequences of transactions in accordance with its programming, it does not, of course, make the position any less embarrassing for Post Office Limited. There is, in my opinion, a substantial risk that any reports generated by a prosecution in this case may be utilised by those who seek to argue that Horizon is defective or otherwise inadequate. There is, of course, also the risk that the dissemination of information concerning this particular flaw may also encourage others minded to commit acts of dishonesty against the Post Office. And can we please scroll down to paragraph 11? You say at the end there, in respect to the charging decision, whilst the public interest test in this case is clearly met, for the reasons set out above, I do not regard a prosecution as being in the public interest. Now, looking at that advice and the charging decision that's made there, do you think that throughout your time acting for the Post Office, you confused what was in the Post Office's private interests with the public interest more broadly?
I think there were times when it was apparent that those interests would be aligned, but there was also times when they were clearly different. And in this case, it would be embarrassing for the Post Office to have to make public the fact that there were not Horizon issues, if you like, but failures within the system to prevent issues such as this. And it was also a weakness which could be exploited. And so it would not be in the public interest for issues which could be exploited to be widely disseminated.
So let's leave that second consideration aside, but you've very clearly said in paragraph 9 that a consideration is essentially preventing publicity of flaws in the Horizon system. because that could be embarrassing to the business.
Yes.
Do you think that that is properly a public interest?
No, I think that's a business interest.
And therefore, we can see here that you have said the public interest test is met, but you don't regard a prosecution as being in the public interest. Might it be there that you have, in fact, confused both the public interest with the business interest?
Looking at this now and the way that paragraph 11 is phrased, I do wonder whether I should have said whilst the evidential test is met.
And how about the second part? I don't regard.
For the reasons set out above, I do not regard a prosecution as being either in the public interest or in the interest of the business. Yes.
So that was a separate consideration that was wrapped up as the public interest in this advice.
I believe I've just wrapped that up very briefly there, perhaps without going into too much detail.
And do you think that this is an isolated advice, or do you think actually, looking back, that was something that was often confused in post office prosecutions?
I'm afraid I can't remember all the advices, I'm afraid.
I'm not asking about a specific written document, but looking back at your career in prosecuting post office cases, do you think that the public interest and the private interest of the business were often confused?
It's possible that they could have been.
And you were involved in them, so do you think they were or they weren't?
I can't recall.
Is it something that you need to recall, a specific instance, or can you just reflect on your career and say whether or not it's likely that you confused the public interest with the private interest of the company?
I think it's certainly possible that the two could have been confused because at times they would have been aligned, and so there was the potential for confusion.
I want to move on to knowledge of bugs, errors and defects during the 2012 period. And the first document I'm going to look at is POL 000-57362. This is an advice that you wrote in January 2012, so this is where I dated the involvement from at least January of 2012 in advising on specific cases for the Post Office.
Yes.
This is a case of Hutchings. If we look at the final page, we can see your name, 4th of January. It's page 3, sorry. Thank you very much. If we could go back to page 1, please. I'm just going to read a few passages from that advice. So the prosecution case, on the 30th of March 2011, an audit was carried out at the Rowlands Castle sub-post office branch, which revealed a deficit in the accounts of £9,743.76. The audit had been arranged after the branch failed to return £30,000 as requested. The next paragraph says, there is very strong evidence to support the allegation that Mrs. Hutchings had inflated the amount of cash held within the branch, usually by inflating the figure for cash held in £50 notes on the days upon which branch trading statements were completed. So there's an inflation of the amount on the day that the accounts were due to be balanced.
Yes.
If we scroll down, thank you very much, the bottom paragraph there, it says, in her prepared statement, she admitted to altering the cash declarations and suggested that she had done so only since the migration to Horizon Online, which she thought was around the months of May or June 2010. The migration date was in fact the 5th of July 2010. Furthermore, she stated that at the time of the migration, all accounts balanced, which was clearly untrue. She also gave examples of problems which she alleged she had experienced with the Horizon system, which do not appear to be of any relevance. Whilst Mrs. Hutchings has denied stealing any money, she has not put forward any explanation as to how the deficit has arisen. And then if we scroll down to the bottom of that page, in terms of charging, it says that Mrs. Hutchings should be charged with a single offence of fraud. This was in January 2012, very much a case alleging problems with the Horizon system.
It was, yes.
I'm going to move to the summer of 2012 now. Can we look at poll 001410408? And this is a case of Jamie Dixon. And it's an email from you to Jarnell Singh. And it reads as follows. Please find attached a copy of the defence case statement in the case of Jamie Dixon. As you'll see, he has said that he does not have confidence in the Horizon accounting system or that transactions were accurately recorded. He puts the prosecution to prove that the money is missing. And you then continue as follows. You say, this is therefore another case in which there will be a challenge to Horizon. I propose to talk to the barrister whom we have instructed and explain that a robust stance should be taken at the plea and case management hearing on the 3rd of August 2012, i.e. the Horizon system works perfectly and that if the defence wish to challenge the integrity of it, their specific allegations should be particularised so that those particular issues may be further considered. And we can actually look at the defence statement in that case. That's at FUJ 00153-918. This is the defence statement. And if we turn over the page, please, to page 2. It says as follows. It says, the defendant was disorganised but not dishonest. Although he thought he knew how to operate the computer accounting system, he now realises he did not understand it fully and puts this down to a lack of training and lack of experience in serving customers. Paragraph 4 says, the defendant understands that in addition, cash in excess of £5,000 is also said to be missing. He does not have confidence in the Horizon accounting system or that transactions were accurately recorded. He puts the prosecution to prove that the money is missing. The defendant denies that he has taken the money. I'm going to move on. I'm going to show you a few documents before asking you about the position in 2012. Can we please look at poll 000462242? This is an email in the case of Ishak, which we're going to look at in a bit more depth. You're sending Sarah Porter there. Is Sarah Porter counsel in the case?
She was in-house counsel in Cartwright King, I think based at the Nottingham office.
Thank you. You're sending her the defence statement, and it says, good morning, Sarah. Please find attached copies of a letter from the defendant's solicitors and the defence case statement. The defence are clearly aware of the current Horizon issues and are on a fishing expedition. This, in my view, is a red herring. The stamp sales, which have been reversed, thereby increasing the stock and lowering the amount of money needed to achieve a balance, were clearly not there at the time of the audit. One final document that I will take you to, it's FUJ 002263331. So we're now in October 2012. If we scroll down to the bottom email, please. We have there an email from Jarnell Singh to Gareth Jenkins copying you in, and it's in relation to a case, but I'll read you the second paragraph. That says, on advice, Post Office Limited have appointed one of their investigators, Helen Rose, as disclosure officer dealing with Horizon challenges. She has prepared a document/spreadsheet detailing all such cases, past and present, approximately 20 in total, although none thus far successfully argued in court. Post Office Limited have been advised to obtain an expert's report from Fujitsu UK, the Horizon system developers, confirming the system is robust. Post Office Limited maintain the system is robust, but in light of adverse publicity from legal viewpoint is that the defence should be given an opportunity to test the system should they wish to do so on consideration of our report. So taking all of those emails together, am I right to say that in the beginning of 2012 and throughout that 2012 period, there was a growing picture of challenges relating to horizon integrity.
That's correct.
Yes. And you had conduct of ongoing cases that raised issues of horizon integrity whilst that picture was building up.
Yes.
We've seen in those emails references to a robust stance and to a fishing expedition. Is it fair to say that, irrespective of how you feel now, the picture we see is one of pushing back against disclosure requests relating to the integrity of the horizon system?
The picture at the time was that Post Office was saying that the system was robust. They were clear that the system was robust, and in those circumstances, we took the view, or certainly I took the view, that only such information as met the test for disclosure should be disclosed to a defendant.
Who in Post Office was assuring you that it was robust?
John L. Singh, head of criminal law, was telling us the system was robust. Stephen Bradshaw, an investigator, was saying that the system was robust. The message that Cartwright King were receiving was that the system was robust. And certainly in a number of cases that I dealt with, the requests for disclosure were either not relevant in some circumstances or too wide, or for information which generally you would not consider would be likely to meet the test for disclosure.
I'd like to test that, and we'll look at the case of Ishak, and we'll look at developments over the period of your involvement in that case, and we'll look at it broadly chronologically. We're going to start on the 29th of August 2012. Can we begin with poll 000462444, please? So we see there a letter from Mr. Ishak's solicitors, Musa Patel's solicitors. We see there under your ref, MS2, and then it has a number. Is that your personal reference, MS2?
MS2 was my fee and a reference number, and the 24676 would be the Cartwright King file number.
Thank you. So you were the solicitor with conduct of this case?
I don't know if I had conduct of it throughout. There was and I think this case was one which was transferred to Nottingham with a view to in-house counsel preparing it with Rachel Panther. But of course, Musa Patels would not necessarily have known of any change of personnel.
So as at the 29th of August 2012, when the defence statement was received, were you the solicitor with conduct of the case?
I don't know if anyone else had been given conduct of it.
Would it be surprising that your initials are at the top with the reference?
No, because that would have probably been lifted from earlier communications. I think there was a suggestion within Cartwright King that once the case had gone to the Crown Court, the file would be transferred to the Nottingham office. It would be then allocated to Rachel Panther and in-house counsel, and they would work on it together. And I think this was one of those such cases that was being transferred to the Nottingham office, and was actually transferred to the Nottingham office.
We know that Rachel Panther was a paralegal, has been described as particularly junior.
I believe she was a junior paralegal, but her role was to work on cases under the guidance of in-house counsel, to liaise with external counsel and liaise with Mr. Jenkins. I believe that this was one of the cases that she was intending to work on with in-house counsel, and I think ultimately, on reflection, this case became a bit of a mess because I don't think much happened for a while. And then it was worked on by her in Nottingham and myself in Derby.
We're going to see quite a lot of emails throughout 2012 and into 2013 with your name, you're sending them.
Yes.
If not on paper the solicitor with conduct of the case, did you consider at least that you were significantly involved in that case?
Yes.
And had a degree of responsibility in that case?
Yes.
This covering letter says, we enclose herewith defence statement prepared for our above-named client, and we'll have a look at that defence statement. It can be found at Pol 000582244. The defence statement is dated the 29th of August 2012. I'm just going to read a few passages from it. If we could scroll down, please, over to the next page. The defendant sets out the general nature of the defence. Are you able to assist us with whose handwriting this is?
I don't know, I'm afraid.
It's not yours,
No, it's not my handwriting, no.
It says as follows in 7.1, there was no appropriation of monies. The Post Office Horizon software/hardware system had in the past on numerous occasions malfunctioned, causing difficulties in reconciling sales, receipt and stock figures. The defendant had reported the same to the Post Office helpline, seeking assistance, but little or no successful assistance was afforded to him despite the said request. And point 2, the defendant had of necessity to make certain adjustments by way of reversals on the Horizon system so as to ensure the sales, receipt and stock figures reconciled. This was done on the basis of a clear malfunctioning of the system and in accordance with the limited training given to the defendant by the Post Office in the past with very limited support thereafter, and not in order to appropriate any sums of money. So he's putting the reliability of the Horizon system front and centre of his defence.
Yes.
Yes. If we scroll over the page, please, paragraph 11, there is a request for various disclosure. By way of example, we have at 11.3 a request for the outcome of all inquiries in relation to other Post Office staff and or contractors who have been the subject of investigation by the Post Office or any other investigative body in relation to allegations of dishonesty related to the use of the Post Office Horizon hardware/software. Number 4, they're requesting the full results, whether provisional or final, of all internal and or external investigations and or inquiries and or reviews, whether instigated by the Post Office or any other body, into the correct functioning of the Post Office Horizon hardware/software system. Number 5 says that they are requesting any internal memoranda and or guidance notes and or other material dealing with the correct or incorrect functioning of the Post Office Horizon hardware/software system. Now I'm going to take you back to an email that we looked at very early on in your evidence. It's Pol 000-46242, and that's your email to Sarah Porter of the 3rd of September, where you say the defence are clearly aware of the current Horizon issues and are on a fishing expedition. Can we now please turn to Pol 000-46243? Do you recall sending that email about the fishing expedition?
I don't recall sending it.
You don't recall sending it?
No. I do accept that I sent it, but I don't recall it.
Thank you very much. We're now turning to an email. If we could look at the bottom of the page. On the 4th of September 2012, there is a plea and case management hearing. And we have here a attendance note of Sarah Porter. Can we scroll down the page, please? She notes there that Mr. Ishak has entered a not guilty plea. If we scroll down, please, The defence are instructing a forensic accountant. The trial has been fixed. And she says as follows: I have made it clear that our stance is that Horizon works and is irrelevant in this case because he now accepts making the reversals, and we say in doing this he was acting dishonestly to cover his tracks. Any particular problems with the system must be fully particularised before any further disclosure made. Judge has indicated the ball is in the defendant's court. Now, where she says, I've made it clear that our stance is that Horizon works, who would have been providing that instruction?
That would undoubtedly have been following a conversation with myself.
She then details, she says, specific requests. One, only such material as undermines our case or assists the defendant in light of the defence statement should be served. And then she refers to 2, 3, 4 and 5. Are these paragraphs referring back to paragraph 11 in the defence statement that we just saw? You'll recall I took you to some of those paragraphs. And she says, I understand that the Post Office are compiling some sort of database in relation to this. Can the progress of this be checked? But until the defence statement further particularised does not require disclosure. It says C, HB, is that Harry Bowyer's advice in the Wiley case?
It would be, yes.
Yes. What did you understand by the database that was being compiled?
I'm sorry, I missed that question.
What did you understand by the reference there to a database? Is that a reference to Mr. Bowyer's advice to keep a central list?
Yes. I think Mr. Bowyer had advised that a database be set up of the unsuccessful challenges to the Horizon system. I think that was following a consultation which he'd had with Jarnell Singh.
So Mr. Bowyer's advice was the 11th of July 2012. Had you, by the stage of this hearing, had you read that advice?
I have read it, but I don't know when I read it.
If we scroll up, please. I mean, her reference to a database, for example, would that have taken you by surprise, or was that something that you...
No, I knew a database was being compiled because the instructions which Cartwright King had received was that the system was robust, and Mr. Bowyer, I understood, had advised that a database should be put together of the challenges, and I know at some point I was copied into an email that Jarnell Singh sent to Gareth Jenkins. I can't just remember the chronology of it, whether that's before or after that, or after this.
I'll take you to that document. But first, can we please look at the top email, page 1 of this. You are emailing Steve Bradshaw, the investigator, copied into Jarnell Singh, and you inform them of the results of the plea and case management hearing, and you say as follows: Sarah took a robust stance in relation to Horizon. It will remain to be seen whether allegations of malfunction are particularised. However, she has asked that progress be checked in relation to the compilation of the database. So, am I right to understand that the response to Mr. Ishak's request was to try and get him to further particularise his complaint?
I thought that was sensible, because if someone could give an example of the sort of issues that they'd encountered, that would enable an expert to look into that.
Was it sensible, or was it a tactic?
No, I thought it was sensible, just in the same way that if you were staying in a hotel and you think you left your car keys somewhere in the hotel might say, well, which room were you staying in, where were you? I thought it would be quite useful to have that information so that we could properly investigate, so we could look into particular allegations that were being made.
Did the defence statement not make those allegations? I mean, we looked at some paragraphs in the defence statement where he says, in the past, on numerous occasions, had caused malfunctions, causing difficulties in recording sales, receipt and stock figures. He also referred to having reported the same to the post office. Do you not think that the post office was quite well placed to make those kinds of inquiries?
Well, certainly Mr. Bradshaw was able to make inquiries internally within the post office, but certainly I was of the view that if you could ask someone, what are you saying, as has happened specifically, that would assist.
And is it your evidence that that was not a specific tactic that was adopted in this litigation?
It wasn't a specific tactic, no.
At no point throughout the Ishak case was that a tactic?
No, I don't believe so, no. I think I wrote at a much later stage, I believe, to Mr. Ishak's solicitors, asking them whether they were going to particularise or asking them for particulars, because I didn't want to get almost to the point of trial and then find that we had then particulars which it would then be difficult to investigate at the 11th hour.
Well, we'll get to that shortly. Let's just have a quick look at Mr. Bowyer's advice. That's at poll 000026567. Thank you very much. If we could scroll down, please. I've said that this is the 11th of July. At paragraph 2, he refers there to the instruction by the Post Office of Independent Forensic Accountants Second Sight Limited to conduct an independent review of 10 cases based on the Horizon system. Are we to understand that you were aware in July of 2012 that Second Sight were carrying out an independent review?
Yes, we'd been informed that the Post Office were instructing Second Sight to carry out a review.
If we scroll down, please, over the page...
Sorry, may I just add to that?
Yes.
I'm not sure whether at that stage we necessarily appreciated that it was Post Office that had instructed Second Sight. I think there was a suggestion at some point that it might have been some sort of parliamentary function that had instructed Second Sight. But in any event, we knew that Second Sight had been instructed.
And that presumably the Post Office would have to liaise with Second Sight
Yes.
to assist them in their investigation.
Yes.
The bottom of page 2 is where we see the advice from Mr. Bowyer that we should identify the contested cases, civil and criminal, in which the Horizon system has been challenged. We should identify the areas of challenge and how we neutralise them, etc. So is this the database that is referred to?
Yes, it will be.
Thank you. Moving to September 2012, could we please look at poll 000060738, and it's page 3. This is a document we're going to come to a few times. It seems to be minuting of work that is being done. Is this a document you recognise?
It is. I believe it's what we called within car wrecking as a billing guide. It would generally list the chargeable work and some of the narrative attached to a time entry, but not all of the narrative attached to a time entry.
If we look at page 3, we're returning to the 4th of September, which was the date of the plea and case management hearing in Mr. Ishak's case. And can you see there about halfway down, just over halfway down this page, it says, discussing with SP by phone and stance to be taken re-Horizon, etc. And it has your name there.
Yes.
Are we to understand that you spoke to counsel on the day of the plea and case management hearing regarding the stance to be taken in relation to Horizon?
Yes.
And do you recall if that was while she was at court, whether it was before, whether you were providing specific instructions?
I'm afraid I can't recall that. I can see that I was engaged on that call for 12 minutes because of the point 2 that's in the right-hand column, point 2 of an hour. I don't know whether she telephoned me from court with a view to clarifying her instructions or whether I spoke to her by calling her. I don't recall. But she would no doubt have been given the brief by the Nottingham team, because it was going to be dealt with in-house by the Nottingham team, and she may very well have phoned me to discuss it.
And I think you've already said that looking at the attendance note and the information, the position that she took in relation to Horizon followed a conversation with yourself.
Yes.
The email that I think you were talking about that attached various things is at FUJ 002263331. And it's the bottom email there. I think that's an email that I took you to earlier from Mr. Singh, referring to the Helen Rose acting as a disclosure officer and preparing a document. And she attached there the spreadsheet of 20 cases. Is that the email that you were referring to?
Yes. And I didn't, at that time, look at the spreadsheet. I don't even think I realised there was 2 documents attached.
Let's look at the 2 documents that were attached. The first one is FUJ 00156648. This is a note prepared by Helen Rose. It's not what we know as the Helen Rose report. It's a note entitled Horizon Integrity Summary Report. Do you recall receiving this document?
I didn't see that at the time. It may very well be that I received it because it would have been attached to an email, but I rather took the view at the time that the spreadsheet, well, I was under the impression that the spreadsheet had been considered by a number of my colleagues, Harry Bowyer, Andy Cash and Andrew Bolts, and I didn't look at the enclosures because I simply looked at the email which said that Post Office's stance is that the system is robust.
Let's look at this report. I'll read to you a few passages. Overview says, over the years, some post offices under investigation for losses have claimed that the Horizon system is at fault. As the post office is dependent on the reliability of our system to be able to prosecute offenders, we've been able to defend our system in the courts. And then it goes on to summarise various challenges. For example, in relation to the Yetminster branch, it says, during the interview, Miss Merritt produced a large document regarding an ongoing inquiry by Shoesmith solicitors in respect of the Justice for Postmaster Alliance, stating that she believed that the Post Office Horizon equipment was the actual cause of this loss. At the start of interview, Miss Merritt blamed the Horizon system and stated she had problems with transferring cash, etc. If we scroll down, there's another branch, Barkham. It's over the page. Summary, Mike Wilcox stated, along with Graham Brander, I met Mrs. Stubbs on the 17th of January, and she was convinced that Horizon was at fault. She has retained daily transaction logs for December to January, in which time she lost £9,000 and is not prepared to release until she can compare it to Fujitsu data. If we scroll down, we go on to the Rinkfield branch. Under the summary there, it says as follows. It says, during the interview, Mrs. McHugh stated that she did not feel 100% comfortable with the Horizon system, but did not appear to directly blame the system for the losses. If we scroll down, under outcome, it says, an indication was given that a plea to count 2 fraud might be acceptable, so long as the defendant stipulated in her basis of plea that there was nothing wrong with Horizon and that she was responsible for the loss and recognised the confiscation would be sought should the loss not be repaid. So a number of different cases where Horizon has been raised not even at trial, but also even at interview.
Yes.
If we scroll down, please, there's reference to the Newsom branch. We can go over the page. The defence challenged the integrity of the Horizon system and employed a forensic accountant. We then get on to West Byfleet. If we scroll down the end of that summary, it says, an expert witness was put forward by the defence to challenge the integrity of the Horizon system. And this is the Seema Misra case. We can see over the page, please. This is a reference to an email that we've seen a lot of in this inquiry. It's this bullet point there. It says, it is to be hoped that the case will set a marker to dissuade other defendants from jumping on the Horizon bashing bandwagon. And it's now it's the conclusion that I'd like to look at. It says, although there have been attempts to discredit the Horizon system via the courts, to date the Post Office have been able to defend the integrity of the Horizon system at all levels. When questioning the integrity of the Horizon system, the defence solicitors are making similar disclosure requests, indicating that disclosure requests and future challenges will be similar to those made in past Horizon integrity challenges. Depending on where the loss was identified, this can sway the disclosure requests slightly into requiring further details and operating procedures around specific transactions, including background processes, i.e. the processing of checks once they have left the office and electronic funds transfer records. So just pausing there on that paragraph there, is there forming an attempt to try and put pressure on defendants to give greater specificity as to the allegations that they're making about the Horizon system?
Not that I was aware of. Like I've said, I didn't read this document at the time. I don't even think that I realised there was more than a spreadsheet attached to Helen Rose's email. I saw this document for the first time when it was disclosed to me in these proceedings.
Let's look at the second attachment then. That's FUJ 001533807. And this is the list itself, the database. We see there are a number of cases that we're well familiar with. The Hamilton case, if we look in H. If we scroll down, Seema Misra. If we keep on scrolling down towards the bottom, we see, if we go to the very bottom, we see there Sefton and Neld, for example. That was a case that is described there as ongoing. Were you aware that there were not only this list of historic cases, but also at that stage ongoing cases that related to the Horizon system?
Well, I knew that this spreadsheet was designed to be a work in progress, so looking back in time, but also then being kept up to date from that point in time. But I didn't open it at the time because I didn't see the need to. I knew that it had been sent to a number of colleagues who had seen it. No issues had been raised internally about it, and Mr. Singh's covering email to Gareth Jenkins was to the effect that it was Post Office's case that the system was robust. I was copied into that and did not think it necessary to go through all of that information, given that it had emanated from Mr. Singh, Head of Criminal Law at Post Office.
But just to recap as to where we are, within a month of the plea and case management hearing in Ishak's case, you had been told, we see there in Mr. Bowyer's advice, about the second site investigation that was taking place. You had received, although you say not opened the database, you had also received that Helen Rose note about various cases. Weren't those precisely the kinds of things that Mr. Ishak's team were after?
Well, I was... The short answer is yes. When I opened the spreadsheet, when I was preparing for this public inquiry, I was actually quite horrified with what I read on it, because whereas I had understood that it was a list of unsuccessful challenges, I think the title actually would have been more appropriate to be a list of unsuccessful challenges and cases which the Post Office dare not prosecute. I was quite horrified to see, for example, and it's not on the screen in front of me now, but on the spreadsheet, there is a case where a sub-post master or mistress was able to demonstrate losses and therefore no further action was taken. So it wasn't exactly as I had understood it to be, literally a list of unsuccessful challenges. That is what I understood was being prepared, but it actually went on to contain more than that. I didn't appreciate there was a separate document by Helen Rose, because when the Helen Rose report, which we use that phrase in a different way, which was ultimately the subject of disclosure, I certainly wasn't sat there with Brian Altman, QC at the time, KC now. I certainly wasn't sat there with Brian Altman thinking, oh yes, well there's another document by Helen Rose. I simply did not realise that that existed.
If we look back at the defence statement in Mr. Ishak's case, can we look at poll 000582444? And it's page 3. It's that list, and it refers there at 11.3, the outcome of all inquiries in relation to other post office staff and or contractors. I mean, that's precisely that list, isn't it?
Well,
it's perhaps broader than that list. But
I think it's broader than that list.
But it would include that list, or the equivalent information.
It would. The request is broader than that list, but also I took the view at the time that unfounded allegations and unsubstantiated allegations were not disclosable, and I understood that list to be unsuccessful challenges on unsubstantiated allegations.
But the request there is in relation to those who have been subject to investigation by the Post Office or any other investigative body in relation to allegations of dishonesty related to the use of Post Office Horizon hardware/software. So it wasn't simply asking for that very specific matter that you're identifying. It was a request for broader information, wasn't
it? Yes, I took the view that it was a very wide request, and indeed I took the view that it was perhaps too wide in its approach.
But having received that list of cases from Helen Rose that had been produced by somebody who was called the disclosure officer, did you not think to yourself, oh, maybe I should open this attachment because it contains a list, and that's the kind of thing that Mr. Ishak's been after?
No, I didn't, because I thought they were unfounded allegations.
So you didn't look at them because you thought they were unfounded?
Well, I was under the impression that these were unsubstantiated challenges, and I did not regard unsubstantiated challenges, unsuccessful challenges, as being disclosable. A bit like, I think that my thought process was this. If you were to ask the Crown Prosecution Service for information about the disciplinary record of a police officer, you don't, in my experience, get to know of all and every single allegation made against that police officer. You'd only get to know of any findings of misconduct.
You would, however, expect the solicitor with conduct of the case to actually look at the underlying material to determine for themselves whether they met that test, wouldn't you?
Well, I'm afraid I didn't open those documents.
Yes, and is that a failing on your part?
With hindsight, I wished I had.
Do you think that it would have been reasonable at the time, having received a list, irrespective of how detailed the list is, irrespective of whether they were successful or unsuccessful, to at least to have opened them to see whether they fit within 11.3?
Well, I didn't think to do that at the time because, as I've already said, a number of my colleagues had already seen those documents to my knowledge. nothing had been flagged up, and we were awaiting an expert report. And so I did not think it necessary to actually look at those documents.
So your colleagues from other cases who weren't charged with Mr. Ishak's case hadn't flagged something that might relate to Mr. Ishak's case?
Well, no one had said, oh my goodness, look at this spreadsheet, look at what it contains.
Is oh my goodness the test for disclosure?
No, it's not. But it would be it was the view I took when I opened them when I was preparing for this.
Number 4, the full results, whether provisional or final, of all internal and or external investigations and or inquiries and or reviews. We've seen in Mr. Bowyer's advice reference to the second site investigation. Do you think that that might have fallen within 11.4?
Well, there were not. I don't believe there were full results at that point.
Whether provisional or final?
I don't know if there were provisional or final. Well,
you make inquiries about that?
There weren't, because second site didn't report until, I believe, July 2013, and this was way before then. So I think it says See Insight 2 in someone's handwriting on that. I think that's probably a reference to second site, I don't know. But certainly second site had been instructed at that point, but I don't believe there were any results from that. And I did go through this list with Steve Bradshaw.
If we scroll down, please, any internal memoranda and or guidance notes and or other material dealing with the correct or incorrect functioning of the Post Office Horizon hardware/software system. I mean, might, in respect of these requests, confirmation that there was this independent firm looking into Horizon have been something that's worth disclosing?
I believe that was disclosed in a witness statement by Stephen Bradshaw.
And at what point was that?
That was, I believe, the following year in 2013.
Yes. And we're here in 2012 dealing with disclosure requests. Can we please look at poll 000583777, the 8th of October 2012. It's a chaser from Musa Patel's solicitors. It's addressed to you. Do you think that might be an indication that you were solicitor with conduct of that case?
Well, they would believe that I was still dealing with it, whether it was in Derby or whether the file at that point had been transferred to Nottingham.
If we scroll down, please. It says, I was expecting the information requested at paragraph 11, subparagraph 6 of our defence statement. I think that's the Horizon data, to have been served by the 5th of October, as per the judge's order at the plea and case management hearing. Then says, I would be most obliged if you could revert back to us to advise not only on the progress of the aforementioned matter, but also other matters referred to at paragraph 11, subparagraphs 1 to 8 of our defence case statement, and of course all relevant material under paragraph 10. So there is a chaser there in relation to those paragraphs that we've just been looking at, and we're in October 2012. I'm going to take you back to your billing notes, and that's poll 000060738, please. Poll 00, thank you very much. It's page 4 now. We're in October. We're going to look at between the 9th and the 11th of October. We may need your assistance in deciphering whose name comes alongside what. It may be difficult to tell because of the way that this is presented, but let's try. If we look at the entry that says the 9th of October 2012, email for case 24676, review of file Upon receipt of Musa Patel's letter, we still await the Horizon data disk from Steve Bradshaw. And then it says, although SP had taken a robust view of the defence case statement, disclosure is an ongoing process, and the developments in the Patel case may well have a bearing on D, that may well have a bearing on the defendant. Do you remember the Patel case? That may be a case called Nimesh Patel that was occurring at the same time.
Well, can I just first of all say that I believe the way the billing system works here is that it will take part of the attendance note, but not the entirety of the attendance note. So it gives a flavour of the narrative in that second column, but then it will then pick up the same for Rachel Panter, for example, below. So bearing on D, I would then regard the discussing progress of case with MJS as the start of Rachel Panter's attendance. And I'm afraid it's just how it would space it out in different columns.
Absolutely. So we see the first entry is your entry,
Yeah.
Which
And I
refers to a case of Patel.
Yes. And I think that it will simply just cut off the number of available characters when it says case may have a bearing on D. The rest of the attendance note will not have, if there was any, would not have been reproduced into the billing guide here. Review of the file, I'm afraid that doesn't tell me whether the file was in Derby or Nottingham, because we had electronic files as well as paper files, and that became more of an issue when files were in different locations because one wouldn't necessarily match the other.
Do you recall the case of Nimesh Patel?
I don't know whether it could be Jishan Patel.
Was there another case with the surname Patel that related to challenge to the Horizon integrity in that period?
I believe there was a case of Jishan Patel, and I believe that I sought a report from Gareth Jenkins in relation to that, and he mentioned a single previous bug in that report with an earlier edition of the Horizon system, and so I don't know. Well, I don't know, I'm afraid, with regard to the timeline, whether I had made that request at that point. I know I did make a request in the case of Jishan Patel for a report.
I'm not sure that was actually the question that I was asking.
But
the question I was asking is about the Patel case.
Yeah.
Were you aware of a case with the surname Patel challenging the integrity of Horizon in October 2012?
Then yes, I was. But the one I'm thinking of is Jishan Patel.
Thank you. And then we get to Rachel Panter's entry, which says as follows: discussing progress of case with MJS. Is that yourself?
That's me.
Deciding whether I should pick the case up from him, as it is very similar to Patel's case. And then she refers to the disk. She says, in terms of disk, then we concluded that I should pick it up. Review of file upon receipt of Musa Patel's letter. We still await the Horizon data disk from Steve Bradshaw. Although SP, and then it's a repetition of, I think, the attendance note that we see above. So it is clear that in October of 2012, you were aware of another case of running alongside the Ishaq case where there were very similar issues being raised.
Yes. And it's clear that what I am saying there is that we have to keep an eye on disclosure. Although Sarah Porter had taken the robust stance, it's an ongoing process. We have to be aware of things that might appear in other cases. And I was thinking that something might potentially come out of another case which we might have to disclose to Mr. Ishaq.
Thank you.
That's why I think it was the Jishan Patel case, because I think I was waiting to see what Mr. Jenkins put in that report, because if he put in that report information in relation to the current edition of the Horizon system, then obviously that would have made me sit up and take notice.
So only if Gareth Jenkins was addressing Horizon Online would it have made a difference to your disclosure obligations in the Ishak case, is that?
Well, I think we're going somewhat forward in the chronology now, but I think in the Jishan Patel case, I received a report from Gareth Jenkins which made reference to a single bug in the in a former version of the Horizon system. Should we just call it Horizon rather than Horizon Online? It was the previous version.
We know it as Legacy Horizon.
Okay, we can use that phrase. So I think I was made aware of a single bug in the Legacy case. I believe that was the Falkirk Calendar Square bug, which was subsequently discussed. And I did not feel that might reasonably assist the defendant or undermine the prosecution's case on the basis that was several years previously and a different version of the system.
Did it not make you question the robust line that had been taken since you started taking on those post office cases?
No, it was a single issue affecting, I believe, one branch several years previously.
Can we please look at poll 000599296? We're now in November 2012, 1st of November. A letter from Musa Patel's solicitors. If we scroll down, please. The trial is due to take place in February. And it says as follows: I write further to the aforementioned matter and confirm that we have received a disk containing core data for the duration of the indictment period. As you are no doubt aware, this should have been served by the 5th of October, and if it is to be the subject of a forensic report, then it had to be served by the defence on the 30th of November 2012. We respectfully write to inform you that it will be impossible for the defence to comply with the judge's order, and at this present moment, consideration is being given to listing the matter for an intervention hearing. Hopefully, we'll be able to address the lack of disclosure in respect of matters contained within paragraph 11 of our defence case statement and were subject to our letter of the 8th of October 2012. So that's again a reference back to those requests that were made in October in paragraph 11 of the defence statement. Sorry, that were chased in October, that were contained within the defence statement.
Yes.
We're going to go back now to the billing record. It's poll 000060738. And can we look at page 6? Thank you. If we could scroll down, please. We have there on the 20th of November an entry that, sorry, if we could scroll up slightly. Thank you. There's an entry 20th of November, and it says as follows: consider proposed letter drafted by RP, that I think is Rachel Panther, suggest amend para 1 by deleting suggestion, maybe more evidence, and repeating fact, J, I think that means judge, said Bull firmly in their court when given opportunity to provide revised defence case statement, particularising Horizon issues. Is that your note?
It would have been lifted from my attendance note.
Yes. And it appears that you are suggesting amending a letter that's been drafted by Rachel Panther. Before we break for lunch, I just want to bring onto screen her draft and your draft. If we could first look at poll 000599407. This is the covering email from Rachel Panther, and she says, please can you just look at the attached before I send it? I imagine the defence will not be too pleased, but that is our position. I had to concede that the discs were served late. They may respond to say that they are unable to particularise any issues with the system until they receive the report. They shouldn't, as that was the wish of the judge at the last hearing, but without having the expert report yet to send to them, that is the best I can do for now. And I'm going to take you now to the letters. Could we bring up onto screen poll 000594416? And if it's possible to also bring alongside it poll 000594409. Thank you. So this one currently on screen is Rachel Panter's first draft. And on the left-hand side is the version that appears that you fed back on according to that billing note.
Yes.
And we can see, if I read to you on the right-hand side, it says, "Thank you for your letter dated the 1st of November 2012. We have been liaising with the investigator in this case and hope to serve any further evidence within 2 weeks' time. However, we look forward to receiving a revised defence case statement which particularises the issue, if any, you may have with the Horizon system as indicated by Judge Rose at the plea and case management hearing." And then the version after receiving your feedback, if we look at that first paragraph, we look forward to receiving a revised defence case statement which particularises the issues, if any, you may have with the Horizon system. We will then gladly review our disclosure obligations accordingly. So reference to further evidence potentially coming has been deleted, and what has been added is effectively a confirmation that disclosure obligations will only be looked at again if there is a revised defence statement. Is that fair?
Well, the first point I would make here is that I would generally advise people not to set themselves self-imposed deadlines. So I would have advised her to remove the reference to hoping to serve evidence within 2 weeks' time, because there had already been delays in receiving information from Mr. Bradshaw. So that's the reason why I advised that be taken out. I was still hopeful that they would serve a revised defence statement which might particularise issues. And yes, we would then obviously review our disclosure obligations.
So is your evidence once again that this wasn't a tactic to put the onus on Mr. Ishak to specify something?
I don't believe it was a deliberate tactic. No, I can see how it looks, but I don't believe it was a deliberate tactic. We were asking Mr. Ishak's solicitors to particularise the issues, which is the approach that had been discussed in court at the PCMH hearing, the plea and case management hearing, and it's apparent that His Honour Judge Rose at the plea and case management hearing on the 4th of September had made the comment to the defence advocate that the ball is in your court. So I was encouraging them, in my mind, to provide information that could be looked into.
I mean, any reference of further evidence coming their way or further information coming their way has been removed, hasn't it?
Well, I didn't think it was sensible to say we hope to serve further evidence within 2 weeks, because if I received that letter as a defence solicitor, I'd be diarising it for 2 weeks and then jumping up and down. I was very much aware that there had already been delays in this case. I don't know why there had been delays. I can't remember why there had been delays in this case, but clearly information had not been forthcoming very quickly from Mr. Bradshaw, and I was trying to avoid any issues arising out of setting a self-imposed deadline.
That's quite a generous reading of that left-hand letter, isn't it? There's no reference whatsoever in that left-hand letter to any further evidence coming at all at any time.
Well, without knowing what information Mr. Bradshaw is going to provide, we don't know whether or not it will meet the test for disclosure. So to say we will be serving further evidence on you when we don't have it, we don't know what it is, I think would be, quite frankly, a little daft.
Sir, might that be an appropriate moment to break for lunch?
Yes, by all means.
Thank you.
So 5 to 2.
Thank you very much, sir.